If you find yourself in federal court, you should be familiar with the sentencing guidelines and the sentencing table, which has 6 criminal history categories on top and 43 offense levels. In the middle, the cross section, is the amount of time you're facing in federal custody if convicted and later sentenced. Now, if you've been paying attention to my channel, you know that I have a playlist called Legal Guides and Criminal Process, where I've previously discussed the federal sentencing guidelines, how to calculate the criminal history and the offense levels, and so on. So if you're interested generally in this topic, after you finish this video, go to the playlist and check out some of the other videos. Today, we're going to focus on the criminal history categories. Specifically, we're going to look whether the state convictions that have previously been expunged count in federal court. Now, you should already know that the federal sentencing guidelines are not mandatory. They're only advisory, meaning at sentencing, the federal judge will accurately calculate the sentencing guidelines, but at the end of the day, it is the judge's decision. He or she can give you a sentence that's higher or lower than what the guidelines prescribe. Again, the guidelines are advisory. But often enough, as defense lawyers, we make arguments in terms of the guidelines, obviously trying to get a lower sentence for our client. And so today, we're going to look whether the state convictions that have previously been expunged count towards the criminal history category. Specifically, we're going to look at the Ninth Circuit case that deals with a record that has previously been expunged in California under Penal Code 1203.4. So, if this is the case for you, take a look at this video, continue watching this. Again, today we're focusing on expunged records. And before we go on, I want to thank you for watching me here on YouTube. If you're new to the Lawstache channel, hit that subscribe button. If you're listening to the podcast version of this recording on Audible or Spotify, please give my podcast a 5-star rating. And finally, if you want to support this channel, consider going to lawstache.com and check out some of the merch.
Quick message from Lawstache. Are you charged with a crime? Or do you want to know your rights if stopped by police? Watch California attorney Anton Vialtsin discuss legal cases from the Supreme Court, Ninth Circuit, and California state courts on the Lawstache YouTube page. Anton has handled hundreds of federal and state criminal cases, has an in-depth knowledge of the law, and has the best mustache ever. Subscribe to the Lawstache YouTube page. That's Lawstache.
Today we're discussing a Ninth Circuit case, United States versus Robert Carver, who pled guilty to fraud and later at sentencing disputed his criminal history category. He argued that his prior convictions in California state court should not count because they were expunged under 1203.4. Now, before we can resolve his dispute, let's focus on the federal sentencing guidelines. Chapter 4 of the federal sentencing guidelines tells us how to calculate criminal history categories. Now, there are 6 categories on the table, and under each category there are points. 0 or 1 point in the first criminal history category, 2 or 3 in the second, 4, 5, 6 in the third, and so on. When you add up the points, that gives you criminal history category. How do we calculate the points? Well, in Chapter 4, the guidelines tell us that any time an individual has been sentenced to more than 1 year and 1 month, so more than 13 months, that would be a 3-point offense. Anytime there's a sentence over 60 days, that's a 2-point offense, and any other convictions count as 1 point, up to 4. So here generally your 3 types of convictions. Now both state and federal convictions count, and so of course here we're focusing on the state convictions that were expunged. As I just mentioned, the guidelines provide a general rule for determining a defendant's criminal history. Add between 1 and 3 points for each prior sentence of imprisonment of a certain length. Now, it is worth noting here that when we're calculating the criminal history category and the points, we're looking at the prior sentence length, not the length of imprisonment. Why do I make that distinction? If you've been previously sentenced, for example, to 2 years in prison, but only did 1 year because of good time credits, it is still a 3-point offense because it is more than 13 months, even though you ultimately did less than 13 months in prison. So again, we're focusing on the length of sentence, not the actual time of custody that you did. The guidelines then define prior sentence, before stating that sentences for expunged convictions are not counted, but may be considered in evaluating an upward departure. After hearing this last sentence, you might be wondering what's in dispute. After all, it seems simple enough. Expunged records cannot be used towards criminal history categories in federal court. But the Ninth Circuit says that a dismissal under 1203.4 is not a true expungement. By definition, expungement means to erase or to destroy. And the Ninth Circuit says that a dismissal under 1203.4 doesn't destroy and doesn't erase your record. Instead, it is quote-unquote set aside. And even the California State Court acknowledges that dismissal under 1203.4 can still be used against you in certain circumstances. Number one, those convictions can still be used against you if you're later convicted of another crime. Now, individuals who set aside their convictions under 1203.4 are still prohibited from possessing firearms and can later be convicted being felon in possession of a firearm. The court also says that the same convictions that were set aside can be used in a variety of civil contexts. And finally, the set aside convictions can still have negative consequences on your licensing. You can still lose your medical license, disbarred if you're an attorney, lose a liquor license, and so on. So the state court acknowledges that 1203.4 does not quote-unquote expunge your record, but rather sets it aside. And because this is not a true expungement, this means that those convictions can still be used against you later in calculating your criminal history category in federal court. So what should you take away from this case? Well, if you're convicted in the state system, it is wise to hire a lawyer who practices in both state and federal court. Of course, judges and prosecutors often laugh and say, "Oh, wait a second, are you saying that your client will later be convicted of a federal crime?" Well, of course, nobody plans on being convicted of another crime. But it is useful to be cautious. Meaning, if you have an opportunity to have the state case dismissed, rather get that state case dismissed than, let's say, plead guilty and have it quote-unquote expunged under 1203.4. So hopefully this resolves the question for you whether expunged record can be used in calculating criminal history categories in federal court. Remember, some expunged records cannot, but if you've been previously convicted in the state system here in California and your record was quote-unquote expunged under 1203.4, that is not a true expungement for federal purposes. I hope you enjoyed this video, and if you did, give it a thumbs up. If you're listening to the podcast version of this recording on Audible or Spotify, please give my podcast a 5-star rating. And finally, if you want to support this channel, consider going to lawstache.com or shop.lawstache.com, where you'll find a number of products, including these Do Not Arrest This Person t-shirts. There's mugs, hats. In fact, I've reworked the whole shop. There's a ton of products now. And in the description under this video, I will include a code so you can take 10% off next time you shop there. Thanks again for all the support. Subscribe, and I will see you next week for another deep dive on another criminal case. Thanks for watching.